need a law degree to be heard in court, if you're going up against your abuser without a lawyer, it might feel like the odds are stacked against you. But with the right words, tone, and evidence, you can take control and speak your truth with power. I'm Tiffany Lesnik with Live Free Legal, and I'm a domestic violence attorney and also a survivor. In this video, I'll show you exactly what to say and do in court if you're representing yourself. Let's make sure your voice isn't just heard, it's believed. Today we're going to talk about going to court without a lawyer. Here's what to say and do. Number 1, script your opening for your case. When you speak in court, imagine you're telling the judge a short, clear story backed up by proof. Here's a basic script you can adapt. Your Honor, I'm here today because I am seeking fill in the blank. A protective order, a custody order, a child support order, whatever it is that you're seeking. I have experience. And then give a brief summary of the abuse or what you've experienced, but no more than 2 or 3 sentences. This is not the time to tell your entire story. I have evidence to support what I'm saying, including text messages, photos, police reports, etc. Lay a forecast of the evidence that you're going to show. And I'm asking the court to consider this information so I can protect myself and my children or my pets and my property. You want your opening to be very brief because many times courts have time restrictions and your opening goes towards that time restriction. If you talk for 10 or 15 minutes and you only have 30 minutes to present your case, that 15 minutes in your opening will have taken up that entire time. So it's very important that you write down a script, you have a script, because that lays a forecast for the court of what they're expecting to hear, and sometimes will influence how they hear that evidence when it's being presented. So it is important to give a brief opening, but it does need to be brief. That is very important. Attorneys, we have openings that we practice all the time that we actually write things down for the court. So you're being like an attorney when you do this. Practice your opening several times before you come to court. Practice it until it sounds natural. You don't want to memorize it. It's okay to bring it with you. You can bring a copy of your opening. It's okay to bring a notepad or paper with you to have your printed opening with you, but practice it a few times so you're not stumbling through it. You sound coherent. It's smooth when you read through it, and occasionally you'd be able to look up at the judge when you're talking so that you look confident. You also want to avoid long emotional rants. Again, keep it short, keep it factual, and also keep it calm. You don't want to get overly emotional and start yelling, looking at the abuser in a menacing way or anything like that. You just want to keep your wits about you. Number 2, evidence. How to present it like a pro. Judges want proof, so here's how to present it effectively. Organize each piece of evidence chronologically. You want to tell a story and you want it to be in order. You don't want to be all over the place because the judge is going to have a really hard time following you. So one way to really present your story well is to have it in chronological order. So this happened first, then this happened, then this happened. You want to label your evidence. When we say evidence, we mean something that can be printed out. So whether that's a police report, a photograph, a text message, an email, something that's tangible that you can actually hold. Your testimony is evidence, but that's not something that needs to be labeled. But if you have something, a piece of paper, a photograph, something tangible that you can hold, we want to label it clearly. And each exhibit needs to be labeled differently. So for example, the first exhibit in chronological order needs to be labeled Exhibit A. And you can buy exhibit labels on Amazon and sometimes in office supply stores, and this is what they look like. And so each of your exhibits will be labeled differently. So you'll have Exhibit A, Exhibit B, Exhibit C, D, and E. And then you're going to put those on your exhibits for the court. You can use a regular pen. I like to use a Sharpie, but I'll just give you an example of how we do that here. And so you'll just label them, and then you'll stick these on your individual exhibits for when you hand up. And you'll say, Your Honor, I'd like to submit Exhibit A. And this is a photo taken the morning after the incident on May 5th showing a bruise on my arm. And then after you're done with that, you talk about the next incident in your story. And if you have picture evidence or a document to support that part of your story, then you would say, Your Honor, I'd like to submit Exhibit B, and you would hand up that particular piece of evidence. In cases where you have a lot of evidence, it can be very confusing and difficult to keep track of documents that are all over the table, right? So if you have maybe 20 different pieces of evidence, you're not just going to want to bring those loose leaf into the court because you're going to get overwhelmed. You also need to make a photocopy of your evidence for yourself, your judge, the opposing party. So you're going to need at least 3 copies of everything. So one of the things that I recommend doing is getting a binder that you can just go get at your local Walmart or office supply store. Get a binder, and then you put all of your evidence in that binder. Here I have tabs, it's 1 through 25. And then you can put all of your evidence in that binder according to the tab. And then your exhibit labels will, instead of being A, B, C, or D, would be 1, 2, 3, 4, 5, and they'll correspond to the tabs. And then you can take this with you when you testify, and it makes it very easy to go in chronological order and just say, Your Honor, if you could go to tab 1 and talk about what's in tab 1 and tell your story in chronological order. Just make sure that you ask for the court to introduce into evidence, or say, Your Honor, I would like to move into evidence the exhibits in tabs 1 through 5. And you can do that as you go while you sit on the bench. This will help you feel much less nervous, help you be much more organized. It will help the judge follow your story. And this is what we do as attorneys when we present our cases. And this is what the judges expect. This is one way that you can definitely present like a pro. A couple other tips when you're talking to a judge is you only speak when it's your turn. You never interrupt the judge. When they are speaking, you are quiet. Also, when you address the court or when you're speaking to a judge, I recommend that you stand up when you're addressing the judge. It shows respect. Number 3, how to handle intimidation or disruption from the abuser. If your abuser interrupts, rolls their eyes, or tries to provoke you, you need to stay quiet and composed. Let them look out of control. The court notices this behavior, you don't need to point it out for them. You have to remember the court, especially family court, sees this type of behavior day in and day out. They're used to it. They know how to spot it. Even if you're afraid, they're not going to pick up on it or they're not going to notice it. They're going to. If it really gets obnoxious and the court is not addressing it, if needed, you can say, Your Honor, I'm finding it difficult to speak while being interrupted. This will also remind the court of the imbalance of power without you appearing overly emotional. Number 4, courtroom presence. Your tone, your posture, and your words matter. So when in doubt, speak slowly and clearly. When we go to court, our natural tendency is to be nervous. And so when we're nervous, we want to speed up how much we talk, right? So we talk a little bit faster, we're not quite as articulate, our words might slur together a little bit more. It is okay to take a deep breath and just to slow down. We talk about this in our domestic violence support groups and some of the seminars that I appear. It's also okay to do a power pose before you go into court. To go stand in a mirror somewhere and put your arms up and be like, I got this. And you would just convince yourself with your body language and your thoughts that you are okay. You are confident. You've got this. And it's okay to go into court and just slow it down. Think about what's being asked and answer the question. Use respectful language. So when addressing the court, say, Yes, Your Honor, not yeah or uh-huh. Use articulate words. Yes, no, be very clear. Sit and stand with your back straight and your hands still. This is even hard for me as an attorney. You can tell I'm sitting here, I use my hands a lot. but you don't want to be sitting there doing this kind of thing, bouncing your legs, bouncing around, fidgeting, moving around a lot, showing that you're nervous. If you need to, bring like a squeegee or a stress ball, something that you can use under the table so that you can be squeezing that to kind of let your nervousness and your anxiousness out that the judge is not going to pick up on or notice. But we want to be confident in our appearance, not fake, but confident. Sit up, addressing the court with respect. When we talk about tone and words, we absolutely want to avoid sarcasm. We want to avoid shouting. We want to avoid defensiveness, reactivity, or excessive crying if you can help it. Now, you can show emotion, and there's certainly appropriate times to cry, but you must stay in control. If you are sitting there the entire time of your case crying and you can't tell your story, the judge is not going to be able to understand what's going on, and they're not going to be able to put those very important pieces of the puzzle together, and you may likely not have a very good outcome. Very important also to not get agitated. If your abuser is asking you questions on cross-examination or their attorney is asking you questions on cross-examination, this is not the time to get nasty or catty or sarcastic with them, saying, well, I don't know about that. What do you think? Absolutely do not respond like that. You need to be respectful, answer the questions directly, yes, no, do not be evasive, do not be circular in your responses, because then it makes it seem like you are being untruthful or you are avoiding, and we don't want to do that. You absolutely cannot allow yourself to get angry, because the judge is going to be looking at both of you and seeing which party is the one who can control themselves, control their emotions, and act with better judgment, especially when it comes to parenting. Representing yourself is hard, but you are more prepared than you think. Your truth, backed with proof, and presented with calm confidence, can absolutely win. I've put together a printable version of the courtroom script I just showed you. If you want access to courtroom scripts and other free materials, guides, and legal templates, join one of our Live Free Legal coaching groups. And during one of our private, supportive, weekly legal coaching sessions, you will have access to a variety of free legal materials, guides, and templates. To learn more about joining one of our Live Free Legal coaching groups, click on the link below. Groups are starting June 5th, and there are a limited number of spots available. They are private groups. They're a community of women who are going through the same or similar experiences that you are with domestic abuse and post-litigation separation abuse. And we are going to talk about things that matter to you, and they're going to help you. They're going to help your children. Remember to give us a thumbs up and subscribe. Never forget, Psalm 46:1 says, God is our refuge and strength, a very present help in trouble. You are not walking into that courtroom alone. You have God on your side, and that is more powerful than you know. We hope that you will join us next week on Tuesday at 7 p.m. as we discuss courtroom power moves, how to show the judge you're telling the truth. No idea how important credibility and the truth is. This month, we're talking all about how to present yourself in the court, which is very important. Presentation and telling your story are critical to being successful in court. Join us next time as we continue to move from fear to freedom. Remember, I am a North Carolina licensed attorney. I cannot offer specific legal advice in any state outside of North Carolina. The purpose of these videos is to offer generalized advice that can be offered in any state outside of North Carolina. If you feel like you need particular legal advice, like am I entitled to alimony, how much child support am I entitled to, I would encourage you to seek the advice of an attorney in your state. We hope that you've been blessed by this week's lesson, and we hope to see you next week, Tuesday at 7 p.m. as we continue to move from fear to freedom.